Ladies and gentlemen, I'm Nairi Woods, Dean of the Blavatnik School of Government, and I'd like to welcome you all this evening, and in particular to welcome friends and supporters of the school, people from the Ghanaian High Commission, and the people who have made tonight's lecture possible. I'm going to come to the speaker in a moment. Tonight is the Africa Initiative for Governance lecture, which is supported by the AIG, which in turn is the creation and inspiration of AIG Fellowship. And I would like to just start by recognizing this extraordinary project that you've set up and welcoming you and Afovwe and your team to the school for another one of the lectures. Thank you. We are so honored each year to host at the school a public servant who has led in an exemplary way in their country. And that's what AIG have created this fellowship to do, to bring to the school, somebody who really exemplifies the kind of public service we would love each of our students to go away and follow. And it's something that our students have asked us. Which is, we learn about the difficulties and challenges of government. Can we also have inspiration about how to do it well? So it's a particular honor to have Chief Justice Georgina Wood with us at the school. She's been a visitor here at the school over the past period, sharing her knowledge and wisdom with students, with faculty, and with other departments across the university. So we've all learnt enormously from her, and we thank you for that. Georgina Wood is now a member of the Council of State of Ghana, having just retired from being Chief Justice of Ghana. She was trained at the University of Ghana, where she got a law degree, and then went on to Ghana Law School and was then called to the bar. She did a postgraduate officers training course at the Ghana Police College, and then began her career working with the Ghana Police Service as Deputy Superintendent and public prosecutor, before joining the judicial service, first as a district magistrate, and then rising up through the circuit and high courts to become the presiding judge of the appeal court in 1991. And then in 2002, she was appointed to the Supreme Court. And then in 2007, she was sworn in as the new Chief Justice of Ghana by consensus, and has served that through, I think, 3 presidents. Chief Justice. So we are honored and delighted to have had you here, and we're looking forward very much to what you have to say this evening. Thank you.
Thank you very much, Naira, for the wonderful introduction. Good evening, distinguished chair, academics of Oxford, ladies and gentlemen who have gathered here today for the presentation on the rule of law and the promotion of sustainable development. I would like to use this opportunity to thank the organizers of this event, particularly Mr. and Mrs. Aigboje Imokode, and then, of course, Dean Naira Woods, for all the assistance in making this trip possible. And I'm also happy for another reason. The fact is not lost on me that I am visiting the timeless of Oxford University, which has produced centuries of global scholars and citizens, many of whom have contributed significantly to the civilization of our world. And so for that reason, I am honored to have been given the opportunity to address all of you in this community of enlightenment. Now, the theme for my lecture is deeply important to me personally, the future of Africa, and for that matter, Ghana's judiciary. This century has been billed as the century for Africa, and it is not for nothing that the influences of global development have touted the prospects of our continent. The continent is well endowed with arable land, material, mineral, and human resources. Not surprisingly, therefore, it has been verified by global development agencies as a market, and a viable one at that, an investment destination. However, sadly, most countries in Africa continue to rank low on the human development scale. For example, my own country, Ghana, with all its resources, for example, gold, oil, cocoa, timber, bauxite, etc., ranks 139 of 188 countries surveyed. And this is from the UNDP 2017 survey. It bears emphasis, however, that the prospect of development cannot be achieved without first putting in place credible systems of governance that assures citizens of the realization of their fullest potential, hence the subject of the rule of law. The subject of governance and the rule of law have especially been heavily discussed in Africa over the last 2 decades, and this is not accidental. The large incidences of misrule on the continent, as witnessed especially from 1970s and largely ending in the 2000s, have necessitated a rethink and change in directions of leadership on the continent. But contrary to the preponderance of news in the tabloids, Africa has, within the last 2 decades, been a continent of hope, a continent buzzing with the energies of its people, and in which the new generation of leaders and governments that are emerging are emphasizing on a new agenda. So today's Africa is a reflection of the hope of the world. And while admittedly there remains a lot to be done, the Africa of today, the Africa of the world, is anxious to break through her dire circumstances, some of which clearly are self-inflicted. Now, if I have spent time, and some time, it is because there is a need for context in this discussion. The issue of sustainable development and the allied subject of meeting the sustainable development goals are quintessentially African. And very few people will deny the fact that the statistics on maternal and child mortality, educational levels, and the teeming mass of unemployable youth remain particularly dire in parts of Africa. Yet, as a continent, Africa is a huge landmass, and arguably the most heterogeneous, and accordingly attempt to always speak of the continent as an undifferentiated mass of people yoked together with a common destiny on all matters and subjects is not quite accurate. So with these preliminary comments, distinguished Chair, I proceed to next consider the subject of the rule of law and sustainable development. Now, a useful point to start the discussion on the linkage between the rule of law and sustainable development will be to explore the conceptual meanings of the two. The report of the Secretary General on the rule of law and transitional justice in conflict and post-conflict societies, published in 2004, states, and I quote, "For the United Nations, the rule of law refers to a principle of governance in which all persons, institutions, and entities, public and private, including the state itself, are accountable to laws that are publicly promulgated, equally enforced, and independently adjudicated, and which are consistent with international human rights norms and standards. It requires as well measures to ensure the adherence to the principles of supremacy of law, equality before the law, accountability to the law, fairness in the application of the law, separation of powers, participation in decision-making, legal certainty, avoidance of arbitrariness, and procedural and legal transparency." Within the acceptation of that term, the rule of law has been urged on emergent democratic countries in Africa, and Ghana's governance regime reflects a deep incorporation of the theory. Now, following the adoption of the 1992 Constitution, followed with pressure from development assistance partners and agencies, including the World Bank, the rule of law has come to characterize the core ethos of Ghana's governance. From the standpoint of the Constitution, key provisions of the document espouse the values of the concept, as I've already identified. These include the supremacy of the law, principles of equality, the prohibition of discrimination, the regulation of discretionary power or authority, the promotion of legal certainty, and avoidance of retroactive legislation, as well as an elaborate set of entrenched human rights provisions, among others. Historical experiences in Ghana largely played a role in the framing of the 1992 Constitution. It is worthy of note that the current development of the constitutional law of Ghana is clearly indicative of the maturation of the governance system of Ghana, although I will be quick to add that the comprehensive nature of the provisions may, in fact, cloud many instances of failure to enforce the law and legal rights in specific situations and contexts. I will now consider the subject of development in the rule of law sustainable development dynamic. In this regard, I prefer definitions that are more pragmatic in the assessment of a country's progress. Development economist Todaro asserts, and I quote, that development is not purely an economic phenomenon. It is not purely an economic phenomenon, but rather a multidimensional process involving reorganization and reorientation of the entire economic and social system. Development is a process of improving the quality of all human lives with three equally important aspects, end quote. Understanding the concept of sustainable development from the standpoint of the broader subject of development is therefore crucial for our discussion. This is very easy to explain, given that sustainable development is a version of development. After all, with the principles of sustainability at the core of that development paradigm. The Sustainable Development Goals, which have been adopted by the United Nations, therefore become a sort of external accountability mechanism by which countries are to gauge the performances in delivering on the goal of improving the lives of their people. If development is the ultimate public good that a government should deliver to its people, then it goes without saying that the delivery of sustainable development must be the priority objective of every government, more particularly of developing countries. I could not resist the temptation of sharing with you, distinguished audience, the definition touted as the world's best, the version proffered by the World Commission on Environment and Development, that is the Brundtland Commission in 1987. And this is how development is described, sustainable development, as development that meets the needs of the present without compromising the ability of future generations to meet their own needs. I'll go over it again. Development that meets the needs of the present without compromising the ability of future generations to meet their own needs. Sustainable development, therefore, is the kind of development model founded on the sustainable exploitation of resources in the pursuit of human progress and happiness. Having looked at the separate concepts of the rule of law and development, it is a good time in this lecture to examine the correlation between these two concepts. In a presentation on the subject, Helen Clark, the first female to lead the UNDP, stated rather poignantly that the term rule of law and development are mutually reinforcing. In other words, that they are not mutually exclusive. At a meeting of the General Assembly in September 2012, the United Nations stated emphatically that, and I quote, "The rule of law and development are strongly interrelated and mutually reinforcing, that the advancement of the rule of law at the national and international levels is essential for sustained and inclusive economic growth, sustainable development, the eradication of poverty and hunger, and the full realization of all human rights and fundamental freedoms, including the right to development, all of which in turn reinforce the rule of law." The issue, therefore, seems evidently beyond doubt and should accordingly not detain us. In the hope that you, my audience, are with me as we adopt the broader conception of the interrelation between the rule of law and development. Discussions on governance, and perhaps more specifically for our purposes, development, invariably tends to shift the focus on the executive and the legislative arms of government. The executive in particular being the institution charged with the day-to-day management of the affairs of state. It is this branch that wields the most extensive powers, aside from keeping and managing the public purse. For all practical purposes, the executive is state machinery, the driver of public policy, most public policies, and foremost particularly in Africa, the provider of society's basic needs: education, health, sanitation, infrastructure, which comes in the form of roads, schools, markets, affordable housing, etc. Now, the judiciary, the justice institution, stands on the other end of the spectrum. Seen as an outsider in government, the judiciary's role is disputed and looked upon with both suspicion and disdain, and sometimes downright skepticism. It seems to me that perhaps deeply etched in the minds of political power seekers is the notion that the construction of courthouses do not rake in votes. So it is no exaggeration to say that the role of the judiciary in development is considered peripheral and is oftentimes overlooked, if not altogether ignored. But I would strongly make a case for the judiciary and argue that this assumption is fundamentally flawed, as it belittles and ignores the unique role of the judiciary as the final arbiter on the rule of law, human rights, checking abuse of power, settling disputes, to assure the enabling environment for a country to develop and flourish. One key lesson that I have learned is that the imperatives of promoting a rule of law-based governance system, which is anchored on a free, fair, and impartial administration of justice, cannot be overemphasized. The moderating influence of the judiciary on the more political branches of government is the basis of constitutional stability and balance. I would like to emphasize that the judiciary must be accorded the same respect and resources and strengthened to enable it to perform its functions. Now, in terms of sustainable development, although the judiciary can be credited with playing its role in ensuring progress towards the country attaining some of these goals, I do recognize that so much more remains to be done, to the extent that the judiciary must not only be committed fully to the cause, but pragmatic steps taken to improve the quality of justice delivery. I must state at this point that it is impossible for any one institution, let alone a judiciary without political power and without a hold on the public purse, to achieve all the sustainable development goals outlined by the United Nations. This is because many of the goals, such as no poverty, Goal 1, zero hunger, Goal 2, quality education, Goal 4, etc., are not necessarily directly within the purview of an institution such as the judiciary. But other goals, such as Goal 5, gender equality, and 16, which is an end in itself, calling for peace, justice, and strong institutions, are more directly within the purview of the judiciary. Relevantly, targets proposed under SDG 16 provide a common framework for governance that focuses on promoting the rule of law, improving access to justice, reducing violence, countering corruption, and so on and so forth. Again, one cannot fail to recognize the limitations of the Ghanaian judiciary in the extent to which it can contribute to the sustainable development fortunes of our country. But judiciaries the world over invariably suffer the same deficit, given that by their very nature and orientation, judiciaries in the Commonwealth as a branch of government are structured to be reactive in action. so that unless and until called upon to pronounce on matters, the courts are literally barred from descending into the arena of conflict. And this is compounded by the obligation to remain neutral and legally bipartisan. These restraints notwithstanding, I would argue that the judiciary plays a critical role in ensuring the promotion of all the SDGs in different ways. So just to give you some examples of how the judiciary can and does contribute to the achievement of the SDGs, I can refer to the measures adopted in Ghana to advance gender equality. The judiciary in Ghana is already doing that through the specialized gender courts and the human rights courts that exist currently, with a focus on domestic violence and other female-related issues. The gender court is gradually ensuring that children and women in abusive relationships, for example, are given justice, and expeditiously too. Also, the Human Rights Court has the potential of ensuring gender equality and women's rights generally, which is one of the fundamental human rights under the Constitution that the court has jurisdiction over. Ghana's judiciary has also, over the years, contributed towards peace and justice. The judiciary has, since the beginning of the Fourth Republic in 1993, constantly held the executive and other state institutions accountable for their actions. This has ensured accountability and adherence to the rule of law generally in Ghana. By introducing the Justice for All program, for instance, and establishing a criminal division of the High Court in a prison facility in Accra, justice has been made more accessible to persons who hitherto would have been denied justice. The judiciary of Ghana takes a view of the law as an instrument of development policy and must continue to nurture and promote the rule of law in order to provide the framework and the foundation for economic growth, poverty alleviation, and ultimately sustainable development. The interpretive jurisprudential philosophy adopted by the judiciary in constitutional and statutory interpretation is the purposive approach, which is essentially based on the assumption that all statutes have an overriding purpose or policy. And it is that purpose or policy, when identified, which ought to be enforced beyond whatever else meaning the language of the statute or constitution conveys. This approach is developmental in character and focuses on the use of the rule of law to attain the developmental ends of society. In other words, mindful of its mandate as the bastion of the rule of law, the judiciary has been a partner in development. Of particular importance is the Supreme Court's pragmatic construction of the law and enforcement of the directive principles of state policy under Chapter 6 of the Constitution. And this has resulted in the empowerment of citizens so that they can demand that government development policy is guided by the values contained in the directive principles. Now, the judiciary and the rule of law under the 1992 Constitution specifically. And at this head, I will attempt a brief discussion of one or two judicial decisions and demonstrate how this has contributed to charting a rule of law regime and ethos for Ghana. At the inception of the constitutional regime in 1992, after a long period of military rule, the Supreme Court established itself as truly the court of last resort. Chapter 11 of the Constitution is devoted to the judiciary, and specifically Articles 125 to 161 is what spells out the judicial power and the various jurisdictions of the various courts. Since 1993, the judiciary in particular, led by the Supreme Court, has taken up the mantle of advancing the rule of law and promoting political, social, and economic development of the country. A number of cases and institutional reforms exemplify the face of Ghana's new judiciary in the Fourth Republic. And I'll mention one or two cases. In the case of New Patriotic Party versus Inspector General of Police, the Supreme Court struck down provisions of the Public Order Decree that purported to limit the ability of persons to freely exercise their constitutional right to assembly, including the freedom to take part in processions and demonstrations in contravention of Article 21, 1D of the Constitution. Now, the case is important because the country had then just entered a new phase of democratic rule after more than a decade of military rule. The court invalidated the revocation order. And in the context of Ghanaian constitutionalism, this was a bold and far-reaching decision, given the turbulent nature of the early days of the newfound Fourth Republic. Yet in another case, the case of New Patriotic Party versus Attorney General, which concerned the constitutionality of the government's declaration of 31st December every year as a statutory national holiday to be celebrated and commemorated out of state resources. It suffices to note that the 31st of December 1981 was the day that the democratically elected government of the Third Republic was violently overthrown in a coup d'etat by the PNDC, leading to the abrogation of the 1979 Constitution of Ghana. Thus, what the government was seeking to do was to commemorate and celebrate the unconstitutional overthrow of democratic government in stark contrast with the tenets of the rule of law. The court thankfully minced no words in upholding the plaintiff's argument that indeed the celebration of such days in commemoration of a coup d'etat not only infringed on the express constitutional provisions, but was also contrary to the spirit of the Constitution. And I'd like to quote the powerful opinion of Francois J.S.C., who held as follows, I quote, "For if the Constitution 1992 frowns on violent overthrows of duly constituted governments and rejects acts that put a premium on unconstitutionalism to the extent of even proscribing the promotion of one-party state, It is naivety of the highest order to expect the Constitution and, in the same breath, to sing hallelujahs in a paean of praise to unconstitutional deviations, past or present. If the past is being buried, the spirit of the Constitution 1992 would frown on the resurrection of its limbs. That is the whole point of the cloak of indemnity conferred in Section 34 of the transitional provisions of the 1992 Constitution. The admission that a violent overthrow of government occurred on 31st December forecloses any sanctioning of public celebration in the constitutional era, end quote. Within the context of Africa's governance experience, the court in this case lived clearly up to the task of upholding the rule of law and safeguarding at the time Ghana's fragile democratic credentials. But quickly, another case that deserves mention is again the case of New Patriotic Party versus Ghana Broadcasting Corporation. The Supreme Court famously held that by virtue of Article 163 of the Constitution, all state-owned media entities, including the state broadcaster, were under a legal obligation to extend to and afford fair and equal opportunities for the presentation of divergent views on matters of national importance. It seems to me that the court had learned its lessons well, that is, its past lessons well, and was now unwilling to sacrifice justice on the altar of political expediency or fear of a dictatorial regime, no matter how powerful it was. The court's determination to live up to its responsibilities during these very early days of constitutional rule deserves special mention, given the immediate past assaults against the judiciary and the rule of law, which acts included haranguing attacks, the violent closure of courts by elements loyal to the military regime of the day, with the most atrocious being the abduction and gruesome murder of 3 justices of the High Court. Their only crime, if they had been guilty of any, being that they had the audacity, through their judicial pronouncements, to uphold the rule of law. I have so far tried to demonstrate that the judiciary in the period immediately after the adoption of Ghana's present constitution made it clear that it was going to reject political impunity and effectively put a restraint on the powers of government in line with the rule of law. Now, the 2000s saw the court build on the successes of the previous decade in order to consolidate these gains. So the most notable case was the election petition of 2012. The judiciary played a critical role in consolidating our democratic gains when the Supreme Court was invited to adjudicate the contested claim that there had been fundamental constitutional and statutory violations and irregularities which had affected the outcome as declared. The exercise has led to reforms of the practice and procedures governing the adjudication of electoral disputes. This period also witnessed some of the most far-reaching reforms that continue to pay dividends to today. The introduction of the specialized divisions of the High Court, with focus on particular aspects of the law, was principally for the purposes of further strengthening the rule of law and administration of justice. These specialized divisions have, over the years, ensured that cases falling within the jurisdiction of these courts are disposed of with the expertise and expedition that is required. The Human Rights Court thus adjudicates allegations of threatened, impending, or actual human rights violations. The original jurisdiction vested in the Human Rights Division of the High Court is inviolable in the sense that not even the Supreme Court can exercise original jurisdiction in human rights matters at first instance. And this has ensured that human rights cases are holistically dealt with at the High Court level, but of course with room for further appeals to the Court of Appeal and the Supreme Court. Now, the Commission on Human Rights and Administrative Justice, a quasi-judicial body, may also access the court for the expeditious enforcement of its decisions and orders. Corruption continues to exact a heavy toll on Africa, retarding national development. Certainly, one area in which the Ghanaian judiciary has and continues to contribute effectively for the state to achieve the SGD goals is in the area of fighting corruption. Thus, of special significance is yet another specialized division of the High Court, namely the Economic and Financial Crimes Court, created to provide a forum for the speedy trial of corruption, money laundering, and other organized crime-related offenses. Similarly, the commercial and tax courts have proven successful in providing more effective dispute resolution systems for commercial litigation. The rule of law will remain important in the development and governance framework of Ghana. Given its mandate under the Constitution, the judiciary is not only best placed, but also obliged to superintend the process and ensure that the values of sustainability are incorporated in the development policy of Ghana within the context of the rule of law. So finally, may I highlight some of the challenges of the Ghanaian judiciary and invite suggestions on interventions that could lead to a further strengthening of the institution, given its importance in the governance of our country. The judiciary still remains poorly resourced and underfunded, despite significant gains made over the years. It lags behind in basic court facilities, modern technology, and other basic infrastructure, whilst other logistical needs remain unmet. It is important that the independence of the judiciary be safeguarded to ensure that the third branch of government executes its constitutional role of checks and balances without external interferences, which has the tendency of undermining the rule of law. So the process of appointment of justices of the superior courts, particularly the Supreme Court, assumes an added significance. A challenge which undermines public trust and confidence in justice administration is the increasing perception that the selection and appointment of justices to the court is heavily influenced by politics and political consideration. This is not conducive to the healthy evolution of the judiciary. Even though admittedly judges tend to have differing judicial philosophies that sometimes align with or mirror a particular ideology, I believe that the appointment process needs to be further streamlined to avoid the usual accusations of bias and perceptions of political party affiliation and other influences. I also believe that a diverse judicial body, and which as far as is practicable, is representative of the community it seeks to serve, with appointees drawn from academia, private legal practice, and not just mainstream judiciary, is a path which must be sustained. But perhaps the more difficult challenge is how to ensure that only persons of the highest ethical values are appointed. So the question is, what credible, objective, and transparent procedures, criteria and procedures can be developed for judging the integrity and competence of potential appointees? Which leads me to yet an even more daunting challenge. How do we succeed in changing the mindset and work ethic of public servants and reorient them for accelerated development? Now, although the Constitution does guarantee financial independence to the judiciary, this does not work out in practice relative to its budget estimates or the quantum that is finally approved by Parliament and its timely release, if at all. These breaches bite the hardest as regards development expenditure, and yet the options open to the judiciary are indeed very limited. I have every confidence, given the stature of this great school of government, that I will have the benefit of your thoughts and suggestions on the issues that I have shared with you today. In conclusion, throughout my long career in public service, I have been a strong believer in the crucial role that judges play in promoting the rule of law and development by exercising their powers to ensure good governance, the protection of human rights, and the rule of law. Ghana's judiciary has come a long way from the early days of independence, where it is accused of having reneged on its responsibilities. What is seen in contemporary times is a stronger institution, still growing in strength, and willing to hold state institutions, including itself, accountable for its actions. Despite the progress that we have made, it is nonetheless my view that a lot more can be done to strengthen the institution, to make it play an even more effective role in justice administration, and so contribute effectively to the promotion of sustainable development. As I bring my discussion to an end, may I call to mind once again my deep sense of honor and gratitude for the invitation and opportunity to share these few thoughts with you. Thank you very much indeed.
Are you happy to take some questions?
Sure.
Fantastic. If you come and sit right here. So the Chief Justice has kindly agreed to take some questions and comments, and suggestions from you. So let's go straight to that. Yes, right at the back. And please do introduce yourself.
Okay, my name is Ajwa. I'm from Ghana, and I'm from the Side Business School here. I do acknowledge the important role that the rule of law has played in Ghana, and I'm curious to understand what has been the extent to which culture has influenced the execution of the rule of law. You did mention the gender courts, but I know that in a place like Ghana, people may not be very comfortable going to report issues of domestic violence. I'm just trying to understand in what way the judiciary has acted in taking all these cultural, situations into account.
Would you like me to gather up 3 questions, or would you like to?
Maybe 2.
2. Okay. We'll take another one. Yes, sir. Yeah.
My name is Alexander Idufo from the School of Geography. You talked about judiciary buildings. Buildings, the state.
Infrastructure.
The infrastructure.
Yes.
I think a couple of years ago, Anas released this video, Ghana in the Eyes of God. And in the pictures that I saw, I also realized the living conditions of some of the members of the judiciary who were caught, taking bribes. I think it was under your tenure when that incident happened. And I think I must appreciate the work you did to clamp down on that. Beyond buildings of judges and magistrates and members of the judiciary, there's also the state of buildings of the prisons, and you've mentioned, I don't know whether all these come under the purview of the judiciary. And if they do, what are you doing to improve? Because my sense is that, I may be wrong, please correct me, my sense is that probably the living conditions of these members of the judiciary contribute to the incidents of corruption that you probably might have dealt with, during. So what are we doing to enhance the living conditions of members of the judiciary? And then, because there's a study that suggests that the living condition of people has impact on their work output at the workplace. And then also the prison, buildings and things like that. Thank you.
Excellent question. Would you like to take
Yes,
those 2?
yes.
So the first is about culture and whether the gender courts.
I'd like to take this one first.
Okay.
And please, are you listening? Yes. If I may correct the facts, the prison service does not fall under the purview of the judicial service. It comes under the Ministry of Interior. So it falls directly under the executive. And then, well, I did make the point, and you heard me quite clearly. I mean, the judiciary is so poorly resourced, underfunded, that that's how come you find judges living in the kind of accommodation and houses that you've obviously identified as not being too habitable. The judiciary depends solely on government subvention to get running. That is providing housing, providing courthouses. And I did explain, the difficulties and the challenges that we have in accessing even our development budget. And so if you are not, if your development budget is not released, obviously you would not be in a position to improve upon the housing infrastructure. By law, actually, the smaller courts in the various districts should be doing better because, again, it is the statutory obligation of the districts to provide courthouses and, judges and magistrates accommodation. But they also sing the same song of sorrow. They also say that they are not receiving their budget allocations, and so therefore it is virtually impossible to do something about infrastructure in particular, you know. But the other point that you made about the living conditions contributing to corruption is something worth discussing among ourselves. I do sympathize, you know, with the conditions in which we work, and we make every effort when the opportunity arises, you know, to improve upon the conditions. So if you've been to Accra, you can vouch that Ghana has one of the most modern, massive high court buildings in the whole of Africa. A 34-court room, modern, you know, with modern facilities and so on. And that was because the government of the day made funds available. So if funds are made available, we will do the right thing. But judging, and I'm using it generically to include magistrates, is a calling. It is a calling. And for me personally, I would say that before you decide to become a magistrate or a judge, check the conditions under which judges work. And nobody puts a noose around anybody's neck to be a judge. You know, so find out what is a pay structure like. You know, do an introspection and then decide for yourself whether you want to be, whether you want to, you know, join this poorly funded institution because you believe in a higher calling to serve your people, hoping that things would improve, and then you can also begin to enjoy the benefits. Now, if you think that you cannot, like this young lady, she's in private practice. Sometimes when I'm driving, you know, back home when I was CJ, I'm going to my chambers, and then I see all these young lawyers with, you know, very nice posh cars. I said to myself, you know, but I say it in jest, we have wasted our time. I use the Ghanaian expression, yabo choboy kwa. It means we have just, you know, but, you know, that's just, I'm not serious. So that is so for any judge to justify corruption on the grounds that she is poorly paid, that is unacceptable. You know, that is unacceptable. But if people have other views, and for your institution, Blavatnik School of Governance, transparency, accountability, high ethical values. If there's some other school of thought, please let's, you know, have it and share.
So the other question, the young lady at the back said, do the gender courts work? You know,
They do. You
and,
know,
and where
yes.
do they, you know,
Yes,
you know, sort of question.
It is true. There are quite a large number of people, especially the further away you move from the big cities, you know, and maybe you live in a small community, a village, and so on. If your child is violated, the tendency is for people the community to come around and say, let's hush it up. You know, it's not good. You know, this will bring disgrace to family A or to the community or whatever. So that it does happen that, you know, some of the cases do not end up in court. Remember, I have described the nature and the orientation of the judiciary, that is judges. You know, we are a reactive institution. We don't go around the streets, highways and byways. Do you have a case? Come, I'll judge for you. Somebody did that in the Bible, but we don't do that. Do you have a case? Look, I'll settle it for you. No, we sit down and we wait for people to bring their disputes, and then we judge it fairly. Now, in judging, cultural values and norms do not play a role at all, especially if it violates fundamental rights. We don't have judges don't have the luxury of listening to cultural values when clearly on the face of it, it violates a constitutional or statutory rule of law or some other regulation. So in the courtroom, when evidence is led on any cultural practice, which, as I have explained, you know, the way we put it is that it is old practices, you know, which, you know, modernity, for example, will not accept, you know, cannot be of value in the courtroom.
Other questions? Yes.
Thank you very much. My name is Ebo Spio. I'm a student of Oxford Brookes University. And this is a question as well as an appeal because of your special role now, a member of Council of State. I don't know who said this. They said justice delayed is justice what? Denied. There are two issues. The first one has got to do with land cases in Ghana. They take a long time, you know, for them to be dealt with. And another issue is got to do with people in prison, in remand. There are some have been there 10, 15 years, and their cases have not been dealt with. Mm-hmm. In your new role as advising the government, what are you doing to deal with these two very important issues? They are, in my view, they are human rights issues.
Thank you. Another question? Over here, please. And do introduce yourselves.
Good evening. My name is Zua Matondo from Zimbabwe, and I am also a student here at the Blavatnik School of Government. Thank you so much, Chief Justice, for being here today. And my question is in regard to the role of the judiciary, especially in Africa, when it comes to combating what seems to be a new trend of rule by law. We see a lot of African governments changing constitutions. For example, to extend term limits. We've seen it in several countries. And if the judiciary's role, you know, through the separation of powers is not to make law, but just to interpret and uphold a document such as the Constitution, what can the judiciary do to combat this new wave? Thank you.
This is a very important question. I will speak about Ghana, or I will use Ghana as an example. Now, if I don't believe, well, I do not know, but we've changed government about how many times? From one administration to the other. It's about 5 times or 6 times. So in the African context, we are quite stable. But I can foresee that if anybody should attempt to fiddle with the Constitution, you know, they're going to rush to the Supreme Court and ask for the necessary declarations, you know, and the Supreme Court is quite able and will be quite able to make the necessary declarations. And when the court makes a declaration and you fail or you refuse to abide by those orders, you commit high crime. And that is the most serious offense in Ghana. But I'm also even beginning to think that, and you know, anybody at all, you don't have to demonstrate that, for example, you are the flag bearer of the opposition party, and therefore you were expecting that elections will be held and you might win and you will become president. No, anybody at all, from the lowest, of course, you must have attained the age of 18 or 21, you know. But anybody at all, even the ordinary villager, can go to the Supreme Court and seek the declarations that I am referring to. I can imagine the Bar Association. We have a very strong bar, independent bar association. And the Ghana Bar Association, really, you know, I must commend them. It's one strong institution which has been very supportive of the judiciary. You know, whenever the judiciary has come under attack, they have taken their role, international role, very seriously. It is an international obligation that when a judiciary is under attack, again, given our orientation, we can't defend ourselves. You can't mount the public podium, call pressmen, and then start arguing. So it is the bar, you know, which normally would rise to our defense. And I can imagine the Bar Association and other professional bodies will not sit down to let this happen. Again, the Ghanaian people, I think, have become more and more aware of their civil rights and liberties. And again, I don't think that will happen. But I do not know. Maybe, Kofi, you have...
And the plea to speed up justice and speed up remand?
Well, again, we've done our best in the sense that we have a fairly large number of courts which are supposed to deal with land matters. So really, land litigation should have moved faster than he's describing. Because again, we've reformed the rules of court, you know, so we use written statements now, which again is intended to speed up the process. But Ghana has huge land problems. And so, to tell you frankly, the largest number of cases that are filed in our courts relate to land. So you can imagine, you know. And, well, we're doing the best that we can, but I know that our friend here, if given the opportunity, should be able to help Ghana to put things in order. So we will not have that unusual problem.
Other questions? Yes, Mike.
And our friend is calling, Professor.
Thank you, Justice Wood. Without a doubt, I think your lecture has demonstrated the wise decision of the Blavatnik School of Government and the African Initiative for Government to select you as our fellow. Leadership has been demonstrated indeed, and really I think the challenge of most things that pertain to governance in Africa around leadership. And one of the things I gain from these interactions are the personal lessons, personal experiences of people like you that we can transmit, you know, across to others, and they may learn and they may, you know, in essence, become better people at it from mentors like you. Now, by the way, I have an interest in an insurance company in Ghana. I thought insurance cases were the most proliferated in Ghana.
No, land. No, not at all.
But,
so that's how come we don't have a specialized insurance claims court.
Now, you have presided over 4 swearing-ins of presidents. And that speaks to longevity, even though I know that one was a case of, one was deceased, and therefore his vice president came in. You were appointed in 2007. Okay. Now, I don't want to guess my age. You know, in Nigerian culture, as in Ghana, we don't try that.
You only have to take the Ghanaian constitution, get your maths right. 2007 You retire at age 70. And,
Okay, so
and this is the School of Government. Yeah. Blavatnik, transparency.
yes.
And, to tell you frankly, I was a visiting judge to Oregon University. And the first lady took me to, they have a model school, beautiful school, so they wanted me to see and know what they were doing. And I was taken to a class of, I think, 8-year-olds. And they were asked to, they had prepared their questions they wanted to ask me. Last one, Ghanaian, hands shut up. Please, may I know your age? And I said, I'm public property. My records are public. The American ladies blushed, because I think it's not in their culture to be asking ladies. I said, well, the records are there, and I've got to be transparent. So therefore, this is it.
So along those lines, in Nigeria, a number of your counterparts last 2 years in office. In fact, we've had a repeated, some not even a year, if I'm right. Some not even a year. To what extent do you think your 7 years?
10.
10 years, sorry. 10 years, sorry, pardon. 10 years in office have helped the Ghanaian judicial system? That's the first question. The second question is this. In Africa, the job of a Chief Justice is not just to dispense wise, transparent justice. Behind the scenes, there are all types of pressures. There are all types of contentions, and it puts great pressure on you as an individual to rise above the fray, so to speak. But could you share with us some of your experiences and how you cope with these tensions? Thank you.
So the first one was, first question. Yes, the short periods of 2 years. Yeah. Well, I think it's your constitution which provides for rotational Chief Justices. Is that not right? Yes, I think so. So the most senior. So, it's like...
Rotation by seniority.
Yes, rotation by...
Convention.
So they call
Convention.
it convention. Oh, it's convention.
Yes,
it's not a constitutional. Oh, well, then if something can be done, because the benefits that I had was that I had 10 years, and so I could carry my policies through, and well, of course, also I had quite a lot of support from development partners, and also I think we were focused to do a number of things.
And what's the toughest decision you've had to make as a judge?
In relation to the pressures?
Yes.
I don't think, I don't know, but in my tenure, if I tell you that any president approached me to ask me to go a particular way or to try and influence judges to give a decision in a particular way, I'll be telling a lie. Maybe that long period in the judicial service, in the judiciary, 40 years. So it's by the 30th year that I became Chief Justice. Then the parameters have been clearly established. Don't go there. It will not happen. So that's why it is so critical that at a very early point in your career, let the world know what you stand for, what your values are, and nobody will come to disturb you. If you don't, they will come and harass you. But I also say this to the credit of the president who passed, at our meals. You know, I remember we went in for the swearing in of some Supreme Court justices. And the president will normally make a few remarks. And he told the judges, and he was dead serious, in the presence of his ministers and so on, he told the judges that if anybody had the temerity to come to you and tell you that I, the president, says, I want this done in a particular way, treat that person with the contempt that they deserve. You know, so when you have people or presidents standing openly to make these declarations, you know, naturally it emboldens you and you hold on hard to what you have. So to tell you frankly, from that angle, no, but certainly, you know, elements, people who are not happy that you are CJ, you know, will make comments and attack and, you know, but I was so focused that I did not permit none of these things. I did not permit any of these things to deflect me or divert me from the purpose which I had set before me. And, you know, removing a judge is not a walk in the park. Ghana's constitutional provisions are so tight that, you know, you just can't initiate the process and say, I don't like this lady as a CJ, so remove. You know, you must either prove a stated misbehavior. And we are looking at evidence, concrete evidence. That's why in the case of the Anas expose, we were able, that's myself and the Judicial Council, resolutely and decisively went through the processes without violating any single one to cause the removal of quite a number of judges. And so for me, knowing also that my hands were clean, I had no skeletons in the cupboard, you know, made me able to work with the confidence that I needed. At even a particular point in time, I had to leave the country at intervals to go to the Republic of Kenya to help them resolve issues related to the judiciary. You know, Kenya set up a board, a vetting board, under their new constitution. And it required every judge, every magistrate who was at posts by a certain date to appear before this vetting board. You know, so you could justify your continuing existence in the judiciary. You know, that was the arrangement Kenya came to with their judges, because they were also not quite happy with their judiciary. So this is the constitution, this was a constitutional requirement. And I was invited, not even invited, appointed by the government of Kenya. And Parliament had to confirm the appointment, you know, as one of 3 external judicial judges, that is judges from outside of Kenya, to join 6 other Kenyans for this vetting process. So the point I'm making is that there was a time I even had to leave the country, go to Kenya to help. I go to Kenya maybe 2 months and then come back home. You know, if I had skeletons in the cupboard, that was the time to open and bring them out.
Yes. Other questions? We've got time for one. Did you have a question, Paul? No. No, I thought you did. No. Yeah, Karen, yeah.
Good evening, Chief Justice Wood. Thank you so much for your lecture and for your very insightful responses to the questions that we've had the opportunity to hear it this evening. My name is Karen Jackson Weaver, and I'm visiting here at the Blavatnik School doing research on women in leadership. And what I'm struck about in your presentation are a number of aspects that relate to your personal and ethical values. I was particularly moved by a part of your speech where you mentioned that judging is a calling. And you also referred to, in several instances, the importance of integrity and the values associated with the type of work that you do. So I wanted to know, particularly for our students and other young leaders here, not just women, but the gentlemen as well and others, if you could talk a little bit about your moral compass and what motivates you to sustain these values and influence others to think about their leadership and what it means to serve in a way that promotes integrity and a commitment to these values.
And can I add on to that question, yes, add a wiggle to it? You have emphasized character, the calling of being a judge. As Supreme Court Justice, you've chosen a lot of other people to be judges in Ghana and in Kenya. If you're human, you've probably made some mistakes on that and appointed people that you later realized perhaps did not have a calling quite as pure as your own. So what do you look for when you're trying to choose a judge of great character? What do you look for, and what have you learned to watch out for?
I think I raised those issues in my paper, in my presentation, and I invited the audience to, because to help, so we can agree on the criteria and the methodology and how you would. But first, to correct you that in Kenya, I didn't choose judges.
No,
yes.
Vetting. Yep.
Vetted them, and it was a 9-member panel. And then also in Ghana, I don't choose judges. I don't have the power to, I am the chair of the Judicial Council, the council that proposes names, and then we go through a set procedure. And in my time, the procedure that we put in place, and I inherited part of it from my predecessor, was to invite those who were interested to write exams. That is up to the High Court for them to write exams, And then, and the exams were administered, questions set, administered, moderated by people we knew we can trust, naturally, a very small group, so you can, having worked with them for a long time, you can say, I know A, B, C, D will be equal to the task. Then it will be followed by interviews, interviews. And again, there's a panel. I don't even serve on the panel. And normally, names would be, of course, I, as Chief Justice, has the right to submit names. And so has the Ghana Bar Association, who are represented on the council. And then the Attorney General also, so normally these are the 3 areas from where names come from. Sometimes, once in a while, the council itself, Qua Council, would also come up with a name. And so I don't have the power to.
But we're still interested. What have you observed about the characters of the people that you work with in the judiciary?
Yeah.
And I'm sure by now you've got an antennae that says that one's a bad one and those 2 are good ones.
To tell you frankly, sometimes it's difficult. I've had situations where people have disappointed, you. And so that's why I raised it. I said, what are the what credible systems? How would I know that Mrs. AIG, for example, would be, how do I? You know, and really we want to find out how would we? Because there's no art to find the mind's construction in the face. So, well, the superior courts are the more important, relatively speaking, courts for Ghana. So, what people are thinking is that let's get some more, especially as you go, as we think of appointment in relation to the Supreme Court, let's get people who have been in private practice and have already made the money that they want to. It is generally thought that, you know, such persons are more likely to be men and women of integrity than, you know, maybe somebody who was never able to do well in private practice. So not just that the person is coming from private practice, but, you know, the person had a successful career in legal practice.
And how does that work out? Are they really? How do they turn out?
How have they turned out? I think they haven't done badly. I don't think they have.
A mixed bag, by the sounds of it.
A mixed bag.
A mixed bag.
No, I don't think they have. And then now, well, in my tenure also, I talked about diversity. And then people from academia, you know, also have joined the bench. Yes. You know, and they have also done quite well.
I think that's a mixed bag too, by the sounds of it.
No, certainly, because, you know, to tell you, I'm being honest with you. Honestly, I do not know what happens behind my back.
Right.
You know, one does not really know. But, so that's it.
Well, Chief Justice, I want to...
No, but please, I'd like to hear from the audience. And then I was going to make one request. You know, here, I've met quite a number of very nice, wonderful people. Professor Collier is one of those that I met. But I realized that they are mostly development economists, or, you know, I didn't see any space for the judiciary or for law. So I do not know, maybe being here and having listened to me, and probably I've been able to convince you of the critical role that the judiciary plays in governance, you will start thinking of, you know, something small.
Yes. Very good. We do have a couple of law professors in the school, but
I'm talking about the discipline,
Yeah.
you know, having a course or something,
Yes.
you know, which may help.
Thank you. Love that's a wonderful suggestion. I think we will have to draw to a close, and we're going to have to invite our audience to give you suggestions when they've had a chance to reflect fully on your remarks.
I see. But please, let's find out. Maybe somebody's ready now.
Is someone ready now? Is someone ready now with a suggestion? There we are. We've got two quick suggestions. We've heard from these
No,
two gentlemen.
suggestions, not questions.
Okay.
How do you know that, you know, this person
Two quick
will turn
suggestions, and then we'll...
Yeah, on the infrastructure angle.
No. Please.
I'm bringing a suggestion on that. You know, it just...
No. Please, that is the list of the problems for the judiciary.
I think the Chief Justice wants suggestions on how to attract great judges.
Minds of integrity. So how?
You recommended 3 judges to us, and they came to the school.
That's right.
And, one was a Court of Appeal judge, and 2 were High Court judges. So training. You nominated them to the oil and gas.
Yes.
That's true.
Yes, and they came.
But seriously, how?
Another suggestion, I think one word which is very important is about integrity. It's absolutely important for somebody to become a judge. And one of the practical ways you can find out, in my view, the people that you are considering, you can check right from maybe try and find out the primary schools they went if you can.
Oh, no.
No, I'm coming. I'm looking for. Look for maybe primary is too far.
Okay.
Check university and other places that they've worked.
Yep.
Just as there's no what's the name, there's nothing.
There's no art to find the ones.
There's no what's the name skeleton in your cupboard. I believe that if you know the people, some of the crucial places that they've worked and their community, they will be able to tell you. I'm not saying I'm a saint, but I believe that everywhere that I've worked, if you go and ask them, if you mention my name, there's absolutely nothing in my cupboard. So I believe it's the same thing. We can check where they worked, and you can find out. And if there's something in the cupboard, it will come out. That's my suggestion.
And well, I think if I could now close, I think we're an interdisciplinary school. We work very well with our colleagues up the hill in medical science. So there's another clear solution, which is to clone the Chief Justice. And my genetics colleagues, I'm sure, could help. So I'd like to end with the suggestion that that's what we do.
But just to add to what you said, I checked the schools. I'll say that I was a fellow at the Blavatnik School of Government. And then presto.
Chief Justice, thank you for being an inspiration to us all. Thank you for tonight's lecture. And a word of thanks also to Aikonofovwe, Bolaji, Imokwede for supporting this wonderful initiative to transform governance in West Africa. Thank you.